boss, Justice Blake.
Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Welcome to the Appeals Court on Zoom. As you can see, sometimes we have technical difficulties. If that should recur, no one will lose any time. We'll just try to reestablish connection like we just did with Justice Blake. Otherwise, all the rules are the same. Each side gets 15 minutes. You needn't use all of your time, and we do not have rebuttal. So it's nice to see you both again. I haven't seen you in a long time, either of you. So with that, I'll call the next case, 2019 P 1069, Commonwealth versus Garner. Mr. Mark.
May it please the court, David Mark for the Commonwealth. Earlier this year, the SJC released its opinion in Commonwealth versus Torres Pagan, which clarified and reaffirmed that in order to justify pat frisk, police must have reasonable suspicion based on articulable facts that the suspect, the person there to pat frisk, is both armed and presents a danger to them. The motion judge in this case did not have the benefit of Torres Pagan at the time he ruled, but it is clear that had he would not have changed his ruling. He in effect found that the Commonwealth had not established the necessary reasonable suspicion. It is our contention that he erred in so deciding, and we would direct the court's attention to, depending a little bit on how you parse the facts, 6 factors that we contend establish the necessary level of reasonable suspicion in order to justify the pat frisk. The first of those, of course, is the fact that the defendant had been arrested and convicted of possession of a firearm, or rather carrying a firearm, second offense in 2011. He had been arrested by the very trooper, Dunderdale, who is stopping him on the night in question. And he served, it appears from the record, he served approximately 3 years on that sentence. He's released in 2014, and he has 3 more encounters with Trooper Dunderdale. On the first of those, which is shortly after he's released, he's arrested again. Dunderdale describes the defendant's reaction first as, "You're out to get me," and then that he calmed down and thereafter had a good rapport. I think later that same year, there are 2 subsequent stops, and in each of those, Dunderdale reports that the defendant and he had what he calls a good rapport, and indeed Dunderdale did not even cite the defendant for the motor vehicle infraction that led to those 2 stops. So in 2017, which is in May, which is the time of the stop at issue here, the defendant is stopped, and his behavior is, this is the second factor here, anomalously nervous, given the fact that he recognized Dunderdale immediately and is calling out Dunderdale's name at the time Dunderdale's approaching. He recognized Dunderdale before Dunderdale recognized him, and he's saying, "Dunderdale, Dunderdale," and then, "Come on, Dunderdale, come on, Dunderdale," as Dunderdale comes up to the car. His behavior is anomalous because they had a good rapport on all previous, on the immediately previous instances where they'd encountered one another. So the troopers were entitled to consider why that should be the case. And here, I believe it's relevant that that Dunderdale was not only the officer with whom he had a good rapport on the previous 2 stops, he's the very officer who had sent, whose investigation and stop had sent this man to prison for 3 years. So his reaction is, could easily be understood by Dunderdale's, "What a nightmare, it's Dunderdale." the very man who sent me to prison is now come up on the car. And his reaction is quite extraordinarily, markedly nervous, not because it's an officer, right? This is not one of those cases where the question is he merely nervous because he's been stopped? This is someone who's been stopped before and has had a relaxed, good interaction, right? So that's two. I would also cite, and I called my brother on this case, the recent case actually out of our county came down Wednesday, Sweeting Bailey. That case is one in which the majority opinion specifically cites the anomalous behavior of in that case, not the defendant, but a confederate of the defendant, Paris, for the change in his behavior from the previous times that person had encountered the police. So Sweeting Bailey isn't particularly on point with this, but it is a case that confirms that a factor the court may consider is that differential in behavior. Right? So the next factor I think that the police were entitled to consider here is the defendant's explanation for his presence on Granite Street. Now, as you may know from the facts, it's a dead-end street. There is a kind of warehouse on one side as your cars, I guess, traveling north, so pointed in that direction. To the right would be a warehouse. To the left were three houses. All three were dark, and Dunderdale says that he thought the third house, which is the closest to where they were stopped, was abandoned. And yet the defendant says he's there to buy marijuana from a friend. So that should be raising some concerns, especially given the fact that after he gets out of the car, he now starts to call to someone. He shouts to someone, hey, or yo, JT, who apparently isn't present or isn't visible to the officers, which, to the extent there's a possibility of a hidden Confederate, that has to give them some concern. All right, so the next factor is he gets out of his car and he backs diagonally away. I have to say, we didn't make much of this, the Commonwealth, in the motion to suppress, and the judge doesn't highlight it, but I would note that Trooper Dunderdale actually uses the term blading to describe the sort of curious manner that the defendant gets out of the car. He appears, as I read the testimony, he backs out on a diagonal. Now, a couple of things here. The motion judge insists that based on his viewing of the photograph, that is I think it's the last thing in our record appendix, that the defendant couldn't have been able to go very far from the car. I think that's just wrong on my view of the photograph. The car was described as having been stopped in the middle of the street. It's not an alley. It is a street on which there are sidewalks on both sides, and then fences, and then houses to the left, and then a warehouse to the right. But he's backing out to the left on a diagonal towards the house. It's clear that he has far more room than to take 2 or 3 steps to move away. So I'm not sure what the basis of the judge's skepticism is there, but I invite the court to look at that photograph. I think it's Exhibit 3 at the very end of our record appendix. And finally, and here again, I think we have an instance of clear error on the part of the motion judge. The judge says that the defendant did everything that was asked of him, and that is not true on my reading of the facts. The defendant is backing away is not compliant with the direction of the officers to move to the back of the car. It is that immediate circumstance that led to his being grabbed by Trooper Ledden and then pat frisked. So it's our contention that if you put all of that together, it amounts to reasonable suspicion. Now, I wanted to address in particular something that was problematic for the motion judge here, and that is his skepticism about the behavior, of the troopers, both troopers' insistence that they could, they read the defendant as being in a fight or flight mode, and that they had both training and experience to recognize that. Trooper Ledden testified at greater length, but both troopers said he seemed to us, he was on the point of flight. Now, so a couple of things. One, there wasn't extensive testimony on this, but the troopers did what the case is asking them. They described the training that they have, albeit briefly, and it involved looking at video of police stops and reading behavior and noting that this behavior then led to flight or fighting, presumably in some instances, but it led to this reaction. And the troopers here are not trying to read the defendant's mind. They're just looking at behavior and recognizing a pattern of behavior that in their experience leads immediately to other behavior, which would be concerning in an instance where they were entitled to detain the defendant at the scene to complete the traffic stop. So if they're entitled
in other words, isn't it really a question of what the troopers believed under the circumstances based on the defendant's behavior, as opposed to them? They did not offer an opinion on what the defendant's belief was.
Right. That it's not. They're just reading behavior. They're not, the judge is a little bit focused on the idea that they couldn't read the defendant's mind. Well, that's true, of course, they can't. But that's not what they purported to be doing. They're just looking at behavior and noting a pattern that leads to other behavior. Now, I would note here the very nature of what Torres Pagan requires of every trooper now is to make a prediction, right? It's not just, oh, I see a bulge in the clothing, that might be a gun. That's not enough now. Torres Pagan makes clear you have to be armed and present a danger. So the fact that to make that call, you have to make a prediction about future behavior. So the officers are doing here only the very thing they're required to do, which is to look at in the current circumstances and make a prediction about the possible future course if they don't intervene and pat frisk. That's all they did here.
Can I ask you, Mr. Mark, to go back to the fight or flight discussion?
Absolutely.
I'm looking at the judge's order on the reconsideration. It's page 7 of his order. I think it's record 57. And the judge seems to parse out the fight and flight and says, essentially, because they thought the defendant was going to flee as opposed to fight them, it adds nothing to the analysis. So how do we consider flight in terms of what the troopers believed the defendant might do in that moment?
If it's, I don't mean to make this into a kind of syllogism, Your Honor, but if it's fight or flight and they're going to remove the option of flight because they are entitled to detain him at the scene until the stop is over, his other option is fight. And that's bad if he's armed, right? They want to control the situation before it gets out of hand.
And they can detain him because of the civil infraction on the tint.
Yeah, they haven't finished giving him a citation.
They have to. Does a person receiving a civil citation have to remain at the scene?
I read the cases. I don't find a case that answers that question directly, Justice Lemire. But I believe the answer is yes, based on the cases that I cited in my brief. That you can. It's the case I think I cite as a seatbelt infraction. Well, you can't wander off. So that in a case where seatbelt, you may be a passenger. So it's not like it's your car, but it appears to me clear from the cases that even in that situation, the police are entitled to have you remain at the scene until they give you the citation. So if it's the case there, all the more so where you're actually the driver, the car is now in your control, and I don't think that the cases contemplate allowing you to abandon the car, and just to flee because you'd rather not deal with that and then let the police, kind of clean up after you and have the car towed and find out where you live to issue a citation. I believe the cases, as I say, I don't think there's a case that's directly on point, but I read the cases that I cited as collectively establishing that you can detain someone at the scene in order to complete the traffic stop. So if that's the case, if they're going to be able to constrain him and he's in this panicked fight or flight mode, then it seems to me that it's appropriate to consider that the flight being prevented, fight is now on the table, and they need to take that option away from him if indeed he is armed. That, in essence, is the Commonwealth's argument. If there are no further questions, I would rely on the brief and the reply brief.
Seeing none, Mr. Kelly.
Good morning, Justice of the Court. May it please the Court, Brian Kelly on behalf of Evan Garner. I'm sorry, on behalf of Bradley Garner. On September 21st, 2017, we had a motion to suppress hearing in the Fall River Superior Court in which there were 3 witnesses, and those 3 witnesses included 2 troopers, Massachusetts State Police troopers, Dunderdale and Ledeen, and my client's then fiance, Sanj Goncalves. And it's notable that during the course of that hearing, there were, I think, 2 or 3 photographs introduced in evidence. One of the photographs was used pretty extensively regarding this where the car was stopped. And significantly, during the course of that hearing, which is in the transcript, I think on page 51, we had a conversation about the exit and Mr. Garner's positioning as it related to the vehicle. And the court's findings of fact, which the Commonwealth talked about a little bit, talk about that. And I think there are 2 notable places where the court talks about not necessarily disbelieving the officers, but just having a different view of the evidence as it came in. And one of those was the width of the street as it related to where Mr. Garner was standing, and how he exited the vehicle and took a few steps backwards. And I think that finding of fact, I would suggest to the court, is a finding of fact that is not, in order for the Commonwealth to persuade the court to overcome, it would have to show the court that finding of fact was clearly erroneous. And I suggested to the court that the Commonwealth hasn't done that. This
But
was
do you need that fact, that finding to be successful on this appeal?
Are you talking to me, Your Honor?
Yes.
Okay.
In other words, you were successful below. For us to affirm the judge below, do you need that? Does it matter what we think about that, about the photograph in the room that your client did or didn't have and backing up out of the car?
Yeah, I think it does matter, because if we're talking about these factors, right? I mean, the Commonwealth has talked about, I think, I miscounted, I think he said 7 or 6 factors. The first of which was nervousness, which I'll double back to. But I think all of these factors matter in this sort of constellation of factors that the courts consider when determining whether reasonable suspicion, in this case, whether reasonable suspicion existed. So I do think
So then if you look at record 64, which is the photo at the end of the appendix, it gives you a pretty good sense of what that street looked like. And as your brother said, it's not a narrow alleyway. It's a street with sidewalks on each side, with buildings on each side. So if we view that photograph differently than Judge McGuire did, what do you say about that?
I think the point I'm making with respect to doubling back to the hearing itself is that Justice McGuire, Judge McGuire, was present for that hearing and listening to the officers as the photograph was up, and we were talking about it. And this was my motion hearing, so I was standing in the middle of the courtroom, demonstrating on page 51 where he was standing, which your honors don't have. And that's why I think it's important to go back to the standard of review with respect to how this court looks at findings of fact that are made by Superior Court judges. They are in the best position to determine those facts, because they're the ones listening to the evidence. They're the ones making determinations on credibility. They're the ones making determinations of how it comes in. And I don't necessarily think it's all here just looking at the transcript. And the other thing I would point out, yeah.
Mr. Kelly, what if we accept as not clearly erroneous the finding by Judge McGuire that he had nowhere to run? And that leaves us with what Mr. Mark said. And that is, based on his behavior, they thought it was fight or flight. And
Okay.
since the judge said he had nowhere to flee, then they're looking at a fight with a guy who's possibly armed.
And so I would go back to Judge McGuire's findings of fact on that, Your Honor, where he, your colleague had pointed out that he essentially, Judge McGuire essentially said, this adds nothing to the facts of this case, adds nothing to the analysis of the case, because, and he doesn't exactly say, I don't buy that or I don't believe that, but essentially I think what he's saying is you've got 3 armed state troopers standing, one of whom is standing right behind my client, right? And as I read, as my memory was, and as I read the findings of fact, these 3 gentlemen are surrounding him, and he's got the vehicle in front of him, and he didn't make any motion. There's no findings of fact in this case, and Trooper Dunderdale agreed. My client never went for his waist. He never made any furtive gestures. He never argued with them. He was never belligerent, I think, are the words that Justice McGuire used. And so what facts are we talking about in terms of fight or flight? He's nervous, right? So let me talk about that for a second. He's been stopped by this officer 5 times. The first time he went to state prison. The second time he was stopped was immediately after he was released from state prison. And the last time he was stopped, as Justice McGuire noted in his findings of fact, Trooper Dunderdale was asking him about information. And so it may have been the case, and we know that people react differently to police presence. We know that for many reasons people get nervous, but maybe it was because he just got stopped by this cop. Last time he stopped by this cop, he's asking him for information. Maybe he doesn't have any information. Maybe he's nervous.
Doesn't Dunderdale testify that on this occasion, Garner's behavior is different from all the others, given the rapport they had established, and he was inexplicably nervous and shaking, and he hadn't seen that with this defendant before.
And that's their argument, and I agree that's the fact of the case, that he's nervous. I quarrel with the word inexplicably. I think that suggests there's only one way you can be nervous around police, and we know that's not true. But they cited this case that just came out, and I wanted an opportunity to just briefly talk about it, because I think it's important to look at nervousness, not just in a vacuum, but in the context of other cases. And as I read this case that just came out, Bailey, I just wanted to point out a couple of distinguishing factors that I think are important for the court to look at. This case, it's a motor vehicle stop where there are multiple occupants of this vehicle. So the police are outnumbered in that case. And this person, Paris, who's not the defendant, exits the vehicle and is acting combative. He takes a combative stance. There's evidence that one of the members or more than one of the members of the vehicle had gang affiliation, which you do not have here. And apparently there was some evidence of one of the members being on.
We do have prior convictions for firearm offenses, though.
I'm sorry?
We do have prior convictions with firearms offenses that this officer knows about.
I agree. And I think that is obviously a factor the court will have to grapple with. But I think it's important to note that it was it 6 years, close to 6 years prior to this offense, which is distinguishable to the case the Commonwealth cited in their brief, which I know I'm going to mispronounce, but it's LEC, I believe, which is that Dorchester district court case where there's a fight at the district court. And these officers, again, see 2 members that they know or have gang affiliation. And, this is also before Torres began. So I think it's important to understand that some of these cases are decided before the benefit of this Torres Pagan case, but there's an exit order based on gang information. More than one member of the vehicle had gun cases, but not convictions. And as I remember it, and I'm just looking at my notes, the stop was extended because of this citation issue, the seatbelt infraction. And so that I think is distinguishable. Elise is distinguishable. I think this case, Sweeting-Bailey, is distinguishable when you look at all the facts. The factors that they want you to rely on are nervousness, the prior conviction, which again is 6 years prior, and how, at least I'm going off their brief, how my client exits the vehicle. And so,
can I ask you this though? I mean, there's a part of me that wonders if sort of the hopping out of the car and saying, take a look, was a bit of a ruse, because he knew the gun wasn't in the car. He knew the gun was on his person. So then they're focusing he's focusing the trooper's attention on the car, and he starts to back up, even if it's only 2 or 3 steps. That suggests to me something sinister.
well, I think it's a cynical but fair view of the evidence. But you know, I would go back to this this Sweeting-Bailey case, which is a case that they kind of had almost similar to what you're talking about. They viewed this this individual Paris's behavior as kind of almost a distraction.
Mm-hmm.
But you know, Your Honor, nobody testified to that. Nobody testified to, well, this is a ruse. I think Trooper Dunderdale's view of the client's behavior was, this is insincere. And certainly we know what happened.
The insincere, the look in the car.
Right. But again, I double back to what the judge found and what the judge in the lower court found and how he viewed this particular evidence after, you know, listening to the evidence and how my client's reactions were. We're talking about, again, a civil violation. He's not a member of a gang. He's got no affiliation to a gang. This is unlike Sweeting and Bailey. It's unlike Elise in the sense that there is no evidence of that. Yes, he has a prior conviction, but it's 6 years old. Sorry.
The issue on fight or flight, though, which the judge did not really focus. He just said it didn't add to the analysis. He didn't discredit it. He just said, you know, it doesn't add to anything. They suspected he was going to flee, and he didn't find that was added anything to the analysis. So we've got to assume that he accepted that they found that he was in that fight or flight mode. If we consider that as one of the other factors now, and the options of being blocked from flight and possibly fighting and being armed, that the officers had a reasonable suspicion that he was armed and dangerous at that point.
Well, Your Honor, if I would agree with you if the judge wrote that, if he wrote on the opinion or in any of the findings that he agreed that the client was in quote unquote fight mode, I would tend to agree with you. But I don't think that's a fair inference from what the court ruled. In my view of reading his commentary, which is this adds nothing to the analysis, he didn't buy that the client was either in fight or flight mode. He just viewed it from the facts that were put on record, which is the client exits the vehicle. The client is not, this isn't an individual who's not following the commands. He's doing everything that they're asking him. He's getting out of the vehicle. He's talking to the police. He's not belligerent. He doesn't try to run. He doesn't do some of the other things that we know usually add to reasonable suspicion.
But the officer is saying at this point that that he had heightened sense of safety concerns. I don't know if that's his exact quote, but he was talking about a heightened sense. So, you know, the case law says we're not supposed to second guess these officers in these situations. So we've got officers who their senses are telling them something. He's saying, I had this heightened sense. We could see he was in this fight or flight mode. He's not obeying everything. He's got this history of being armed or possessing firearms. He's acting differently. That whole, like, as you said, constellation of factors, I mean, it seems as though the judge found all of those factors essentially, but just came out with a different conclusion under the law.
The only thing that I would quarrel with in what you just said, Your Honor, is that he didn't find that the client was not following directions. That's exactly what he did not do. He found that the client was following every direction that was asked of him. Now, the Commonwealth disagrees with that, but, you know,
I think he made a finding that he was following. I believe that he made a finding.
And, you know, so again, just doubling back to what Torres Bagan said, what evidence is there that he's armed and dangerous? Not that he's going to flee, not that he's, you know, not that he has a history, but those factors that we're talking about, you know, and that excited nervousness, which I, again, say there could be other reasons for it, that he's exiting the vehicle, again, surrounded by 3 armed state troopers, and the history, which is 6 years old. So I see my time is up. I appreciate the court's questions. I hope I've addressed everything. And I would just rely on my brief and ask the court to affirm the lower court's decision.
Thank you. As Patricia mentioned, if we have any problems, we'll suspend and get back to you, and no one will lose any time on their arguments. I'm Justice Meade. With me today are Justices Blake and Lemire. With that, I'll call our next case is 2018 P 301 Commonwealth versus Brown. Ms. Opperman.
Thank you. Good morning, and may it please the court. My name is Erin Opperman, and I represent Miss Adrienne Brown. I want to summarize the facts of this case briefly because there are numerous errors claimed on this appeal, and I think it's very...
Please do it briefly because we are familiar with the facts and you do raise a lot of issues.
I do. Okay, I will jump straight into the issues then. And I will begin by talking about the erroneous decision by the trial judge when he admitted a photo of 3 knives seized from the bedside table of Miss Brown. The knives were seized almost immediately after the incident between Miss Brown and Mr. Jones. The facts relevant to this particular decision are there was, as your honors know, an altercation on the front porch of Miss Brown's apartment building. Her apartment was on the 2nd floor. She encountered Mr. Jones as she was returning home from work. Mr. Jones did not live in this apartment, but had been hanging out at a neighbor's house drinking for approximately 4 hours prior to Miss Brown's return from work.
So can I ask you this? So this came up a couple of times during the trial, right? First, the judge excluded it and found it of marginal value, and he didn't change his mind. This is Judge Veery. Didn't change his mind until the defendant testified she acted in self-defense and used the weapon that the victim possessed. It was only then that it probative value shed light on the circumstances.
It was at that time that there was potential probative value. However, the trial judge did err in his reading of the relevant case law. Unfortunately, the trial judge relied almost exclusively on the case of Commonwealth versus Otsuki, which is a somewhat unique and anomalous fact pattern and legal reasoning with respect to the issue of when a weapon can be admitted at trial when it is not alleged that that is the weapon used in the alleged crime. In order to admit a weapon such as this, where something was found in Ms. Brown's house, where the alleged crime did not take place in or in her house or near the knives found in her bedroom, the court must have found or needed to find that it was physically possible that the knives could have been used in the stabbing.
Why can't it just show that she has the ability to access knives because she possesses them?
Because that would be a propensity argument.
Doesn't Otsuki say otherwise?
I would say that Otsuki does not say otherwise, and again, that Otsuki is an unfortunate set of facts that is very anomalous. And I did cite in my brief, and I would direct the court to Commonwealth versus Barbosa, where the Supreme Judicial Court explains the anomalous nature of the Otsuki case. In Otsuki, a witness testified that they saw the defendant 2 months prior to the shooting of a police officer with a gun. The witness testified that the type of gun was not the same type of gun that was used in the shooting. Under that set of facts, the gun should not, or the witness's testimony about the prior viewing of the defendant with the gun should not have been admitted. And what the SJC explains in Commonwealth versus Barbosa is that the reason for the anomalous nature of the ruling in Otsuki is because the witness could have been wrong. And it could have been possible, physically possible, for the gun seen on the defendant there 2 months prior to the shooting to have actually been used in the shooting. In order to
Okay,
admit,
I'm sorry. Let's assume that it was an error to admit this photograph, an abuse of discretion. So the prosecutor, then we have to look at how the evidence was used, right? So the prosecutor argued that these knives were evidence of deliberate premeditation in the stabbing, and in other words, first-degree murder. And the jury acquitted her of first-degree murder and only convicted her of manslaughter. So given that's how the improperly admitted evidence was used, where's the prejudice?
that is what the Commonwealth argues on appeal. And unfortunately for Ms. Brown, that's not how the evidence was used at trial. The prosecutor made an aside remark during closing that there was premeditation. However, the way that the prosecutor primarily made use of this evidence was to argue that Ms. Brown was lying when she said she used Mr. Jones's own knife to stab him, which he had pulled out during the course of this altercation, and that, quote unquote, we know she possessed her own knife because she had a whole drawer of knives to choose from. The prosecutor made a very direct and clear argument that the jury should believe that Ms. Brown was carrying a knife on her the day of the altercation and disbelieve her testimony that Mr. Jones, who we knew was carrying a knife, pulled out either that knife or a second knife, and she used that knife. The prosecutor argued that they should disbelieve Ms. Brown's testimony and believe she was carrying her own knife on her that day simply because she possessed other knives in her house. All parties at trial agreed that none of those three knives could have physically been used that day. It was, to me, it was clearly error, but the prejudicial nature cannot be understated in this case, because what the jury found in convicting Ms. Brown of voluntary manslaughter was that, one, there was reasonable provocation. So they clearly believed that Mr. Jones was doing something that he shouldn't have been doing. And they also believed that Ms. Brown did not act in lawful self-defense. So the only issue, the issue that the entire trial turned on was whether she acted in proper self-defense. The prosecutor utilized the photo of the knives to suggest, one, Ms. Brown was lying when she said she used Mr. Jones's knife, and two, that, again, quote unquote, we know, not even it's possible, but we know that she was carrying a knife on her because she had these other knives in her house.
Well, we do also know, counsel, that she stabbed him 3 times. So that we can't ally to that. And what could easily have been, regardless of this photograph of these knives, they could have believed that she was justified in acting in self-defense, but she did so with excessive force, which results in manslaughter.
Unfortunately, we don't know. We don't know why the jury found she did not act in lawful self-defense. But this court cannot, as the standard is, cannot be sure that the photograph of knives and the suggestion that Ms. Brown had a propensity for carrying a knife on her, of which there was absolutely no evidence, this court cannot be sure that that had but slight effect. This court cannot be sure that it did not prejudice Ms. Brown, especially in the light.
But we're reviewing for an abuse of discretion.
I'm sorry?
We're reviewing for an abuse of discretion.
Abuse of discretion, and I would suggest that it is pretty clear that the judge committed culpable error in misunderstanding the relevant case law. Moving on to whether there's prejudice, this court, in order to find that there was not prejudice, must find that there was but slight effect. In the situation where Ms. Brown was acquitted of first degree and second degree murder, where the jury again necessarily found there was reasonable provocation, but that she did not act in lawful self-defense, the issue at trial was whether she reasonably apprehended fear or serious bodily injury, and whether that fear was reasonable. If the jury believed that there was that she had a propensity for carrying a knife on her, they might have been less likely to believe she was afraid, less
But
likely
the
to believe
photograph, correct me if I'm wrong, the photograph is of 3 knives that were in a drawer in her house. Is that right?
Yes.
So that doesn't show that she had a propensity of carrying a knife. If anything, it shows she had knives at her house.
The photograph doesn't show that, but the Commonwealth at trial argued that she did have a propensity. And they argued that the fact that she possessed knives in her home proved essentially that she used her own knife when she stabbed Mr. Jones.
No,
Well,
Go ahead.
isn't
Go
the
ahead.
Commonwealth's argument acceptable on the facts that the victim was found with a pocket knife on his person after he was removed from the scene, and her claim that she had picked up his knife, I mean, he could have had more than one knife on him. But it's equally, I don't think it's out of the question that the Commonwealth could not argue that she was carrying a knife. He had his knife on him.
I don't think it would have been out of bounds to make an argument she had a knife on her. What was prejudicial error was that they used her ownership of 3 knives in her home that were never removed from the home, that were never, where it was impossible for her to have. We know she didn't go back into her home and put a knife there. We know that these 3 knives had absolutely nothing to do with this incident. So it wouldn't have been error to make that argument. What was problematic and what resulted in prejudice in this case was that the prosecutor used the fact that she possessed knives in her house to make that argument. If the prosecutor had made that argument without suggesting that because she had these 3 knives in her bedroom, that makes it more likely that she had a knife on her, then there wouldn't have been a problem. But the prosecutor really made a very direct propensity argument. If I may move on to the other, I think, second most important issue. The court also committed error when it allowed 4 of the 5 witnesses who witnessed portions of the incident to testify that in their opinion, Ms. Brown was not in danger, that they had no fear for her safety, and that they had no concern that she was in danger. Under Commonwealth versus Jones, this is blatantly not allowed. Again, it goes directly to the elements, 2 of the elements of self-defense, whether or not Ms. Brown did fear serious bodily injury or death, and whether that fear was reasonable.
The question in Jones, though, was they asked whether they believed that the victim was about to do harm to the defendant. And that's not what occurred here, is it?
It is what occurred here. And the language was slightly different.
Which witness testified to that? What witness testified to that?
Ms. Mercado, Ms. Graham, Ms. Hunt. And
They all said that the victim was about to do harm to the defendant, or did they describe their behavior as non-aggressive and they weren't concerned for her?
Both. They described Mr. Jones's behavior specifically, which certainly was permissible, and then they went on to give the jury an inference and a conclusion about the significance of his behavior. When they say, when the witnesses said, I had no concern that Ms. Brown was in danger, I had no concern for her safety, it was the exact same thing as saying, I did not believe Mr. Jones was going to harm her. There was no other potential source of danger or harm to Ms. Brown. The slight difference in wording here, I would articulate or describe the testimony in this case as a passive version of the testimony in Jones that was problematic. The reason the testimony is problematic is because it provides a witness opinion on whether or not Ms. Brown had any reason to fear serious bodily injury or death, and whether, if she did so fear, whether that fear would be reasonable. Those are 2 elements, again, of self-defense. The decision on whether those elements were met was squarely and solely within the province of the jury, and they were capable of deciding whether or not Ms. Brown had any reason to fear, or whether or not her safety was in danger, or whether there should have been any concern for her safety. So by providing that,
I guess then again, I'm left in the same place, that the jury could have disbelieved all of those witnesses and found the defendant acted lawfully in self-defense, but did so with excessive force.
and again, we don't know what the jury found with respect to why the elements of self-defense were not met.
But we never know what the jury finds, and we're still charged with evaluating whether prejudice occurs.
And in this case, the court, again, cannot be sure that the problematic testimony, the photograph of the knives, and particularly the way the prosecutor made use of these pieces of evidence at trial, this court cannot be sure that it didn't have any more than slight effect on the jury. The prosecutor argued in closing that Ms. Brown had a propensity for carrying knives, and argued that there was no reason for her to apprehend serious bodily injury or death. And that pushes it over the line when it comes to whether there was prejudice in this case.
Okay, thank you.
If there are no other questions, I would rest on my brief for the remainder of the hearing.
Mr. Nadeau.
Thank you, Your Honor. Good morning. May it please the court. I'm Stephen Nadeau on behalf of the Commonwealth. I'll begin where Attorney Opperman began, with the photograph of the knives. The question of whether this photograph was admissible was left to the judge's discretion. The record makes pretty clear that he took his responsibility seriously and acknowledged the potential, with full awareness of the potential pitfalls of admitting this evidence. Nonetheless, once the defendant testified that she was not carrying a knife, and she took a knife from Mr. Jones, this photograph became relevant to show I think it bears emphasizing that this was not a photo, that these weren't kitchen knives that you might find in anyone's house, or this wasn't one knife. So if she has one knife, she probably has more. She had sort of an assortment of I don't know if they're unusual exactly, but not just household knives in her
They're in a junk drawer with things like lighters and crafts and stuff like that.
Yes, yes. So it's not necessarily that she has this like arsenal nicely laid out next to her bedside, but she does have several knives. So the idea that she had a knife on this occasion is not out of the ordinary, and where the defendant, through her own testimony, put her possession and acquisition of a knife in issue, the judge thought that made a difference there at the margins, and exercised his discretion to admit it.
But what was the purpose of that photograph? Ms. Opperman suggests it's for propensity. I mean, isn't that exactly what it showed? She had a propensity to have knives, so there was not an indication that any of those knives were used in this crime. There was no allegation that any of the knives were being used or had been used in this crime. Is it an impeachment to say she didn't pick up his knife, she had these other knives, so she would have potentially had a knife of her own, or is it just propensity?
Well, I don't think it is propensity at all. She does in fact own these knives, and under Commonwealth versus Otsuki, it shows that she has access to a group of knives. It's not just that she has one knife that she's known to carry or anything like that. It's just that she has sort of an assortment accessible to her, and where the access to a knife is a factual issue introduced by the defendant through her testimony. This photograph was probative on that issue.
All right.
If there are no other questions regarding the knives, I would move on to the second issue Attorney Opperman addressed, which is the demeanor evidence. As with all the issues, I think any question of prejudice has to be considered with the overall fact that the Commonwealth here was proceeding on a first-degree murder charge of particularly deliberate premeditation, and as well as extreme atrocity and cruelty. But the Commonwealth never argued sort of in the alternative down the line. The prosecutor was not, if you don't buy first-degree murder, here's our argument on second-degree murder, or here's our argument on manslaughter. The Commonwealth's theory was always that this was a first-degree murder, and the jury's conviction on manslaughter, notwithstanding their rejection of a self-defense claim, shows that the jury was thoughtful in exercise in their deliberations and not overwhelmed by any particular piece of evidence, in particular this demeanor evidence, which I would suggest does not go to either party's state of mind, Mr. Jones or the defendant, but merely just goes to help set the scene that all these witnesses are observing. It helped characterize the argument as one that was less aggressive than the other nonviolent argument between Mr. Jones and Quanija that occurred shortly before, and also helps set the scene that this isn't sort of a Wild West showdown between two people where you've got them squaring up and the bystanders are running inside and shutting the doors and windows because something's about to go down. Rather, this is a nice afternoon. People are kind of hanging around outside. And they're certainly aware that there's this discussion going on, but it's not overwhelmingly distracting or causing anyone to any sort of chaos or fear or anything like that. As far as anyone knows, there's just sort of an argument or a discussion going on that sort of suddenly erupts into this stabbing that seems to come out of nowhere. And in contrast to Jones, where they're asked, what did you anticipate the defendant in that case was about to do, or the individual in that case was about to do? In this case, it's what did you see, what was the behavior observed, and what was sort of your own reaction to that? Were you concerned? No. And again, the fact that the jurors did not take this evidence and use it to not only reject a self-defense claim, but to find the defendant guilty of murder.
You'll admit, though, that that's an odd way to do the question, though, right? In other words, isn't it once you establish what the behavior was in the non-aggressive part on the victims, isn't what's left supposed to be dealt with in argument rather than asking for conclusions from witnesses?
Perhaps, but I do think this helped set the scene of what was going on in much the same way in Commonwealth versus Orban. The fact that the witness, I believe it was a wife, testifying to her husband's demeanor on the phone when he was intoxicated or something, and there had been a shift in his demeanor from an interaction earlier in the night where he all of a sudden was angry, and his demeanor caused her concern. Now, her concern along the same lines may not be directly relevant, or that might be something for argument that his behavior change was concerning for whatever reason. But nonetheless, the court there found that impression of the demeanor or the behavior was admissible. And then if there are no other questions on the demeanor evidence, I'd go down just to touch base on the remaining issues. If the court has any questions.
I do. On the last issue, the spontaneous utterance or the dying declaration, Ms. Offerman argues that it was unnecessary piling on. There was already evidence of the stabbing, and the going to jail part was an improper opinion on guilt. And everyone agrees that it's a spontaneous utterance. And you spend a lot of time in your brief talking about why it wasn't testimonial, and Ms. Offerman does not make a confrontation clause argument. So why can you now, because it's not in your brief, why wasn't this unnecessary since she admitted that she stabbed him?
Well, I think it goes to sort of his state of mind at the time, you know, in the moments before he collapsed on the street as he's dying. It goes to his own surprise at what happened, his alarm at what has happened, that this isn't just a flesh wound or a minor thing. He is alarmed. He's summoning help.
What about the going to jail part?
So I know Attorney Opperman argues that you know, is a comment on the sentencing or the criminal process, but I think, or I would argue that that's really just a reflection of the common understanding that in the wake of a violent crime, if you've suffered a violent attack, when you call 911 or you call the police for help, you understand there's going to be a police reaction. It's not just the ambulance shows up; it's that the police arrive and arrest, detain, whatever it may be.
Didn't need that statement, even in a first-degree murder indictment. There was no reason to put that in.
Other than I think that it was his, it was part of just his complete statement that she stabbed me, she's going to jail. It was just kind of part of the scene. It's what he said. Just before I agree that I don't think it adds anything.
Was it on the 911 tape, or did witnesses testify to it?
Witnesses testified, and so they kind of overhear this, and it's been a little while, especially getting back to the office. But I don't recall whether it's clear exactly what he was saying to the operator versus what may have just been him calling out, but. Again, I agree with, I think it was Justice Blake who mentioned, I don't think it adds much, but even if this portion of the statement should have been excised and excluded, it is severable from what came before it, but in light of—
reviewing it for substantial risk, was it preserved?
No, substantial risk.
Yes, that's my recollection. But even if under that higher standard, I don't think there's any indication of prejudice or substantial risk given the conviction here on not even a second-degree murder charge, but only on the manslaughter charge. And if there are no other questions from the panel, I would rest simply on the brief.
Seeing none, I'll thank you both, and we'll take this under advisement.
We are live and on the record.
Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Blake and Lemire. If we run into any technical problems, as we did in the first two cases, we will do our best to reconnect with you, and no one will lose any time, so all will be heard. Everything will run like it does ordinarily when we're in court. Each side gets 15 minutes. You needn't take it all. We've read your briefs. It's my suggestion to get right to the point. With that, I'll call our next case. It's 2020 P97 Commonwealth versus Santos. Ms. Kenny.
Thank you. Good morning. May it please the court, Jessica Kenny on behalf of the Commonwealth. This is the Commonwealth's appeal, an interlocutory appeal from the allowance of a motion to suppress. As you're aware, this is based on the four corners of a search warrant, and the judge in a very brief margin ruling just indicated that there was insufficient probable cause. I think obviously that both sides have agreed here that the issue in this case is whether the controlled buys, the three of them that were done, were sufficient to satisfy any issues with the veracity prong of the analysis that may have been left open by the fact that the CI was never used previously, and any independent investigation that was done prior to the buys. Pont obviously is the case that controls here, and it came out after this case happened, but obviously Pont talks a lot about what the police need to do in their affidavits in these multi-building situations. And I stress that Pont didn't exist at the time that this was being written, and so obviously now officers are aware that they may need to describe more than they used to in the past, but even without that guidance when this affidavit was being written, I suggest that there are some striking differences between the Pont cases and the other cases that come before that coexist with Pont, and this one. And the first and foremost being that in Pont, in Montero, in Warren, in all those cases, it's a single controlled buy. And here there are 3. And that is a very important difference, because when you're discussing whether or not an informant would have the ability to essentially pull one over on the police and be obtaining these drugs from somewhere else, every time that informant participates in a controlled buy, I suggest that any possibility of that diminishes greatly. And so it's important here that there are 3 controlled buys. In this case, unlike in Pont, the CI made these calls to the target in the presence of the police. And that again is incredibly important when you're trying to determine whether someone is making, a false claim and really obtaining the drugs somewhere else. You could argue that you could call and order drugs from someone and not show up, and the police might not know, and that the dealer might not care. The second time you call, they're most likely going to say something to you about the fact that you didn't show up the first time, but you're certainly not going to be able to do that 3 times, ordering drugs from a target and then not going to pick them up at the location that's agreed upon without someone saying something on the phone about that. In the defendant's brief, he points out that it's not clear that the police could hear the other end of the conversation, even though it's clear they could hear the CI's end. And I disagree with that, because during the 3rd buy, there's a specific reference to a statement that the target makes on the call, and it's not in the affidavit being described as something that was told to them. It's written in there in a way that it appears that they heard this on the other end of the phone. And so I suggest the fact that they were made in the police presence, and it appears that the police could at least hear part of the conversation on the other line, again, strengthen the probable cause from these 3 buys.
What is there in the affidavit, Attorney Kenney, what is there in the affidavit about the building?
So the building, it's described, first of all, by the CI indicating that they enter the building and it's immediately adjacent to the door that you enter. The inside of the apartment is described as having more than one door to enter. And then the CI is limited, obviously, to the locations that he or she is allowed into the building, into the room. But they describe that in all of the buys, they're allowed into the living room. So they have knowledge of what the living room looks like. And I know that it can be a little generic, but then specifically that the drugs are always pre-made, they're always pre-packaged, and they're almost always retrieved either by the target or her associate in the kitchen. And again, I understand that most apartments have kitchens, but I still suggest that the CI, obviously, you don't have the type of detail like you do in Warren, where you have which bedroom the drugs were in and under which bed and which dresser drawer you would find something in. But that's simply because this particular target is serving his or her customers in the living room and utilizing the drugs from the kitchen.
Ms. Kenney,
I think
does the affidavit disclose how many units are in the building?
It does not. It says that it's a 3-story building, and I think we're particularly hindered in this pattern because the apartment in question is on the 1st floor, and it's only known as apartment number 1. So there's not even a lettering system where, like in Pont, we could infer that how many, there could be between 12 and 36 apartments based on the numbering system. And even in, I think it was Warren, that's a 2nd floor apartment. So you could appreciate that the CI might have a better understanding of the layout of the building, because they at least have to travel through some of it to get to the target apartment. In this case, the fact that it is the 1st apartment, it doesn't allow us to know much more about the inside of the building, but I suggest that that is actually a strength to the CI. If the CI had more information about the layout of the building, despite the fact that the CI only needs to go into the very 1st apartment immediately adjacent to the door on the left, that would again lend us to believe that the CI really is going somewhere else inside the building other than where this target apartment is.
And wasn't that actually one of the issues in Ponte, is that the CI went in, took an elevator, got off on a floor and went to a particular door, and there was no way to know that he went to the apartment that he said he was going to?
That's correct. And in this case, I think that goes hand in hand with what Pont says about the police, not being able to follow someone into a building. Not only do we have it very clear in the affidavit here that would be impossible, because it's the immediate door adjacent to the entryway. So there's nowhere else to go. We don't know if there's a hallway or a staircase or an elevator, but I suggest in a 3-family, there wouldn't be an elevator, or a 3-story, there wouldn't necessarily be an elevator. but there's nowhere for the police to go. And so again, that makes this different than Pont in that there's no second or third floor. Even in Warren, they went to a second floor apartment. So the police can't do that. I want to make sure I mention that the overdose, because I think that's huge in this case. When you're talking about the information that the police had even before the controlled buys, that is a major corroborating factor. The fact that police had responded less than a year prior to that exact apartment where the target resided, and there was a fatal overdose, and that the target admitted to police in there that they knew that the roommate had been using the particular type of drug here that the CI was alleged to be buying, I think is incredibly significant. One, because again, it shows the presence of drugs and illegal narcotic activity in this apartment at a short time prior within the year. But two, it again helps to solidify that information that the CI is providing about the layout of the inside, and again, solidify that reason why the police, it's not feasible and it's not safe for them to be able to go in there. It is again described by the police that respond to that overdose death as the immediate left of the entrance, directly adjacent to that. And again, the third party that we have here makes this a very different situation. So the way that this target is utilizing their distribution ring is to send really a security guard to the door to let you in when you call. And so the police can corroborate that the CI makes this call at the door, consistent with, again, the information that's provided. And then he or she is let into the apartment. Again, I think that language there is consistent with what the CI told the police would happen. And, and so it essentially escorted then by this third party, this co-conspirator, to the door, again, making it impossible for the police to follow them in any way or conduct any surveillance of that. But again, I think it's better, it makes it better than Pont, because in Pont they said there was no other observations of the CI interacting with anyone else. And at least here, this is consistent. Very importantly, during that second buy, we have what appears to be an uncontrolled buy happening at the same time. And that is really important for the veracity of the CI as well, and strengthens the CI's veracity, because there is no way that the CI could have known what the police were seeing on the outside of the building. So the only way for the CI to be able to provide that information was if he or she actually witnessed it themselves, right? Because they're not out there with the police. And remember, this person walks into the building exactly in the same manner as the CI, makes a call at the back door. Moments later, they're let into the building. Then the CI indicates that, from the inside, they saw this happening, that the phone rings and there's a nod, and that third party goes and lets them in. And remember, the police say it's 1 minute after the CI goes into the building that they see this other buyer come to the back door, 5 minutes that they're inside the building, and it's 1 minute later that the CI comes out. And even the CI is able to essentially say that same timeline by saying, right after I arrived there, somebody else came in, that person made their purchase before me and then walked out shortly before me. And again, there's no way that the CI can make all that up and make that detail up, because clearly doesn't know that the police are seeing that from outside unless the CI is actually witnessing that. And that is huge as far as corroborating what occurs. There's an issue in the third buy that was brought up in the defendant's brief, and I just very briefly want to address it. It appears to be an address completely unrelated that was left in the affidavit. I suggest that that's a typo or a Scrivener's error, that in every single buy, the affiant uses those same first two sentences, that they followed the CI directly to the residence of the target and listed the residence, and then the CI went directly to the back door. And for some reason in that third buy, there's an address that is never ever referenced whatsoever in the affidavit in any other place left in there. And so again, I certainly don't believe that means that they let the informant go somewhere else and walk into another apartment. It was just appears to have been left in there because in the very next sentence, talking about that very same residence, they used the correct address that is the target in this particular case. I'm just reviewing my notes. Is there anything that I haven't addressed with regard to this particular buyer, this particular affidavit, and the distinguishing factors between Pont, Warren, Montero, the cases that are on point that the court would like me to address? I'll rest on my brief then. Thank you.
Thank you. Mr. Daniels.
Good morning, Your Honors, and may it please the court. Josh Daniels appearing for Mr. Santos. Before the Commonwealth may rely on a CI's tip to establish probable cause for a warrant, the Commonwealth needs to show that the facts within the affidavit's four corners establish the CI's veracity as a reliable source of information. Here, the Commonwealth concedes, and we just heard it, that the CI's veracity and thus probable cause itself rides on the validity of the three drug buys, all of which suffer, I suggest, from at least the same deficiency addressed in Ponte. I'd like to begin with a point that my friend on the other side raised about the number of buys. I don't think the number of buys alone really gives any of them corroborating power if none of them are controlled. So a controlled buy, I suggest, is analogous to a controlled experiment. You're essentially trying to see, if we make sure the informant doesn't have any drugs on them before they go in, and they do have drugs on them after they come out, the hypothesis is that wherever they went, that's where the drugs came from. The problem is we don't actually know within the building without relying on the very same CI whose veracity we haven't yet established yet, where the CI went. They say that they went to apartment 1. My sister suggests it's implausible that they could have not gone to that apartment 3 times. I suggest equally plausible, perhaps equally plausible is good enough, I think, that there could have the CI might have obtained the drugs from another unit in the building all 3 of those times and said it was unit 1 to misdirect the police's investigation, which a criminal informant has powerful incentives to do, as we've briefed. That ties into the second.
But that's just speculation, right?
I don't think it's speculation. I think it's a failure of the Commonwealth's burden to actually show that the CI went to the unit that they claimed that they went to without circumstances, independent investigation.
How is this different from what the SJC has said in Desper and the recognition that police can't reveal their surveillance point by following an informant around an apartment building?
Well, I think Desper, I think Ponte reconciles the case law very well by saying that principle applies only in small buildings, or at least buildings that present the same security and secrecy concerns. And what Ponte says is that information about the size of the building and the concerns that might prevent closer supervision actually have to be in the affidavit. And I don't think either of them really are. And I don't really hear the Commonwealth or read their brief really as saying that the affidavit is sufficient for you to infer that this is a small 3 or 4 unit building, as we were talking about in Warren and Desper.
But doesn't Ponte also provide for the explanation as to why the surveillance couldn't occur? In other words, as Ms. Kenny pointed out, the CI was led into the back of the building, the door, by another individual. So any surveillance or any attempt to be there to watch what door he then goes into could have been detected by the third individual that let him in, the so-called bodyguard, I think she called him.
Well, the rear door.
But doesn't Ponte provide that if they can't surveil even in a multi-unit larger building, that's okay if it's consistent with other cases like Warren and Desper?
So I think what Ponte says is that if they can't surveil, that at least needs to be in the affidavit. My position is it's really not in the affidavit. I'd like to take the fact about the rear door and the doorman, bracketing the fact that the affidavit doesn't actually, in so many words, confirm that the police saw the doorman. But there's still the front door, which the police have no explanation really for why they couldn't have maintained surveillance from that location. And I think comparing to Ponte, as Justice Blake, you pointed out, in Ponte, the target unit is literally next to the elevator that the CI is using, and it's not entirely clear. I mean, I guess one can infer that there are stairs somewhere, but like it's not entirely clear that you know, one could indulge the same sorts of speculations, I think, about how the police in Ponte couldn't have actually had surveillance on that floor. And the problem Ponte pointed out is, well, that's supposed to be in the affidavit. And if you really want that to be in the affidavit, you have to attach consequences to its absence. Because
But what about the fact that Ponte issued after the decision in this case?
I don't think that actually matters because, of course, you know, everyone's right that the police officers here didn't have the benefit of Ponte. The police officers in Ponte also didn't have the benefit of Ponte, and there's no suggestion that Ponte's application is prospective only. I think the default rule is that it applies to all cases that are still pending, and this is one of those cases. So, and the Commonwealth hasn't argued, I think, that the Ponte shouldn't apply on that.
Well, if Ponte sets out a new rule, wouldn't it only apply prospectively?
No, it applies to all cases that are still pending when the rule is issued, or it. That I believe Your Honor, Justice Lemire is thinking about new rules and whether they apply to convictions that are already final or cases that are already final on direct review. I think the default rule is, if it's a new rule, it applies to all pending cases, even ones that arose after the rule was even ones that were pending or ones that arise after the rule was announced. I'd like to get back to the point about police incentives, because it's really important to, I think I can't emphasize enough how important it is that if you really do want this information, if the court really wants information about the size of the building and the feasibility of closer surveillance in the affidavit, then you really do need to attach consequences when the information isn't present, as I suggest it's not present here, because the dynamic here is the information can only, either it helps the case for probable cause or it hurts the case for probable cause. If it hurts the case for probable cause, that's an incentive not to put it in. So unless there are consequences for not putting it in, unless there's a downside to that, you're not going to get that information in any case in which it would make a difference. Just looking over my notes.
Do you think the fact that there were 3 controlled buys here is different than the 1 buy in Ponte?
I don't think different. It actually does make a difference, Justice Blake, and the reason why is basically repeating a flawed experiment multiple times doesn't increase your confidence in the hypothesis of the experiment, is the way I would put it. You really do have to look at whether.
Would the converse also be true, that if the CI did 3 buys at the same apartment in the same manner, that's consistent with the information that the CI had before he did the controlled buys?
Right, but the key is whether it actually did happen at the same apartment, and the only source that we have for that information really is the CI himself or themselves, and that's exactly the thing that we're trying to figure out whether we can trust, whether we can credit for probable cause purposes. I do want to address the issue of the 3 calls, or the calls that were made, that the Commonwealth says were made to the target. Again, this is an example of something that actually just relies on what the CI is telling the police. So the police claim that they corroborate both numbers. They don't actually use both of them in the controlled buys, but put that aside. With what the subsidiary facts in the affidavit actually say is, I watched the CI make a call and arrange a drug deal with the person on the other end. And by inference, the CI tells them that the person on the other end is this Lil person who is the target. But there's nothing in the affidavit that actually suggests that the police did anything independent to verify that that is true. And with respect to the 3rd call, I don't think it's clear from the affidavit's language that, you know, the information being relayed in that paragraph of the affidavit is not information that was also just relayed from the CI to the police after they got off the phone.
Can I take you back to the question of the number of units? At
Yes.
record 22, which is page 11 of the affidavit at paragraph 24, sub 1, the trooper describes 8 White Avenue as a 3-story multi-unit residential apartment dwelling.
Yes.
So why isn't that DESPER?
I believe in DESPER we had the number of units. We don't here. I'm not sure I'm following your honor's question.
Well, I mean, you know, I wrote Ponte and,
Yes,
and spent
I
a lot
know
of time thinking about the number of units in an apartment building and what you could and couldn't infer from that. And when I look at 24 sub 1, it's a 3-story multi-unit residential apartment building. Apartment 1 is in the left front of the residence. It goes on to tell you the color and the mailboxes and the like.
Yep.
It seems to me that under DESPER and Warren would cause it to fall outside of the concern that I expressed in Ponte.
So I don't think, I think that would only be true if you can actually make the leap to the inference that this is a small 3 or 4 unit building. And I don't think that information alone gets you there because we don't know what the footprint of the building actually looks like. We don't know what the mailbox, how many mailboxes there actually are. And the description of where the unit is, if you look at the full description, first door on the left suggests that there's more than one door on the left. And the fact that the hallway and the front steps are in the center suggests that there are units on the left and the right. I think this could very easily be a bigger size 12-story building. 3 times 4 is 12. Perhaps there are even more units in the basement, as is common. And you know, that takes us into the realm of the size of buildings that Ponte says present different concerns. I'd also rely on the parking lot, which the affidavit says, I believe at paragraph 7, has multiple cars in the parking lot when they drive by. I think the natural reading of that is that this is a parking lot that's associated with this building that's heavily used, probably means a lot of people live in that building, or a good size number of people live in that building, because we need multiple parking spaces. And that's another indicium that this is not, you know, the triple decker that we were talking about in Warren or in DESPER or in Figueroa. I do want to, before I run out of time, I do want to address the anomalies in the second and third controlled buy and the second and third drug buys. I'm trying not to call them controlled buys because my position is that they're not controlled. So with respect to the third man, I can think of several possibilities that you know are equally consistent with the CI reporting to the police that the third man shows up. One is that, you know, the police could have mentioned it during their debrief. We don't actually have the text of that conversation. It's not a bizarre possibility to imagine, it seems to me. The third man could have gone to the same other unit that perhaps the CI bought the drugs from all 3 times. Again, we just have the CI's word that he actually went to unit 1 as opposed to some other unit on the 3rd floor, and he's trying to misdirect the police. The third man could have gone to the same place. Or the drugs may have come from the third man himself. With respect to the Crescent Street apartment, I would urge the court to just put the third buy aside entirely. The idea that this is a scrivener's error was not raised in the Commonwealth's brief at all. There's no support for it in the 4 corners of the affidavit. And I don't think it's appropriate to credit a representation at all made for the first time at oral argument. In closing, I just say that aside from the number of buys, which I don't think matters because none of them is appropriately controlled, this case is a lot like Ponte and it should come out the same way. We'd ask that you affirm the judge's order. And if there are no further questions, I'm happy to rest on my brief.
Seeing none, I thank you both and we'll take it under advisement.
We are live and on the record.
Thank you. Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Blake and Lemire, who will be the panel for this case. If we run into any technical difficulties, we will suspend and we will reestablish connection with you, and no one will lose any time that was allotted. Each side has 15 minutes. You needn't take all of your time. We do not entertain rebuttal. With that, I will call the next case. It's 2020 P147 GRIECO versus Williams. Mr. Boletto.
Thank you, Your Honor. Good morning, Your Honors. My name is Michael Boletto, and I'm here today on behalf of the appellant, John Michael Williams. This case turns on the interpretation of a contract and whether or not said contract is ambiguous. The contract.
Mr. Boletto, can I just ask you, Judge Salinger never did a written finding and conclusions, right? It's the transcript that he read into the record?
That's correct, Your Honor.
Okay. So do I understand that the argument about ambiguity that is that when you read together the production agreement and the operating agreement, the lack of a remedy is what you say makes it ambiguous?
The lack of a remedy, Your Honor, as well as the lack of the mechanism for determining the breach.
So let me ask you this. If the remedy was liquidated damages, right, that would be presumably set forth in the contract and there'd be a dollar figure. But what if the remedy was specific performance of the contract? That would not necessarily be set forward in the contract. So why does the lack of a remedy cause it to be ambiguous? I know you want to talk about breach too, but sure. Remedy is what I'd like you to first address.
Well, Your Honor, the court, what I would suggest, Your Honor, is the court basically, the lack of a remedy is the lack of an essential term. Because under the case law regarding ambiguity, if the case lacks an essential term, then it is by definition ambiguous, and lack of a remedy is an essential term, Your Honor.
So what do we have for a case that says that the lack of a remedy in a contract ipso facto makes it ambiguous?
Well, there's no case cited in my brief specifically as to the lack of remedy, Your Honor.
So this would be the first case that would say that.
Potentially, Your Honor. Potentially, specifically, Your Honor. I mean, there's plenty of case law that talks about the lack of an essential term means it's ambiguous. Sort of general case law I've cited.
I don't disagree with you with that premises. What I'm trying to figure out is how the lack of a remedy plays into it, because oftentimes people file complaints seeking all kinds of equitable relief for an alleged breach, and not all of those, including things like specific performance or an injunction, not all of those are included in a contract. So I'm trying to figure out why here the lack of a remedy clause makes it ambiguous.
Well, I would say, Your Honor, that it's the lack of an essential term, because in this case, Your Honor, the thing to keep in mind is that there's no argument that he didn't produce the movie. So there would be
and there's no argument that he misappropriated hundreds of thousands of dollars.
There is an argument as to that, Your Honor. The defendant in the case, Mr. Williams, took the position that the remaining money was for marketing and distribution of the case. Now the trial,
but not for 3 cars for his family.
No, I don't disagree with that, Your Honor.
Okay, so you would at least agree that he misappropriated some, let's call it just some of the funds.
Yes, Your Honor, some. There's a dispute as to the amount, obviously, Your Honor.
So then is it your view that the contract had to say something like, if you misappropriate the funds, I can sue you to recover those funds?
No, Your Honor. The contract had to say what the remedy would be. Obviously, anybody can sue, but would the remedy be specific performance? Would the remedy be, would there be punitive damages? Would there be something else? There's always a contract, the lack of the remedy makes it means that there's no essential, that lacks an essential term of the contract, Your Honor. Addressing just specifically your idea of the lack of remedy, because obviously the lack of the mechanism for determining breach is also part of our argument about the lack of.
Just staying with remedy for just one more question.
Understood, Your Honor.
What should the contract have said if somebody misappropriated funds? What would make it unambiguous?
Unambiguous would say that you would have to return those funds within X amount of time, would make it unambiguous, or or some other remedy that the parties in the industry would decide would be the remedy, because you have to keep in mind, Your Honor, that these are people that are involved in the film industry, and the remedy in that particular industry might be different than a remedy in another particular industry, Your Honor. That's why the contract and the terms of the contract are so important, because based upon the industry that they're in, there could be a variety of different ways. I'm not in the film industry, Your Honor, so I can't say what other contracts would have what other remedies, but that's my point, is that there would be some remedy that might be specific to that particular industry, Your Honor.
Now, your brother says that this claim is waived at
sorry?
page 15. Your brother says at page 15 of his brief that this claim about a lack of a remedy is waived. Can you address that?
Well, Your Honor, the parties always argued that the contract was ambiguous. There was never, I mean, the judge's ruling basically addressed that, because one of the issues at trial was ambiguity of the contract. And I will point out that there was several pretrial rulings where the judge found that the case wasn't ambiguous, but it was the contracts weren't ambiguous. It was argued at trial that the case was ambiguous, and the fact that the court found it necessary to rule on that tells you that that was a live issue at trial, Your Honor. So that issue was raised.
Why do we even have to get there? The judge found on two grounds: breach of contract and breach of fiduciary obligation.
Yes, Your Honor. Well,
You did not appeal the second ground, correct? Correct?
Well, no, Your Honor. We appealed the entire judgment, Your Honor. And I would say this about the fiduciary duty. The breach of fiduciary duty rests on the same facts as the breach of contract. The breach of
separate cause of action. Has nothing to...
I agree, Your Honor, but without the breach of contract, there's no breach of fiduciary duty, in the sense that the findings that the judge made relative to the breach of contract are relevant to the breach of fiduciary duty, in the sense that the fiduciary duty exists because of the contract, Your Honor. This LLC was...
But an LLC where somebody is misusing funds does not require any contractual obligation other than the fact that they existed within the LLC.
Well,
And the amount of monies found by the judge to be missing is the damages under the both breaches. So we could say there's no argument. You present no argument on the breach of fiduciary duty that the judge was incorrect.
Well, Your Honor, I would suggest, in response to your question, that the LLC was created for the sole purpose of producing this movie. There's no argument about that. And the obligations of the parties relative to that movie are laid out in the operating agreement and the production agreement. The judge himself decided that those two were to be read as one agreement. So the operating agreement and the production agreement are one contract, and we're not disputing that they should be read as one contract, Your Honor. So under the terms, the fiduciary duty, which is actually created by the execution of an operating agreement, is actually folded in to the breach of contract. It's the same thing, because the operating agreement and the breach of contract are treated as one contract, Your Honor. So that's why the contract is really what is a practical matter, what creates the fiduciary duty. Without that contract, there's no LLC, there's no fiduciary duty, Your Honor. And so the point here, Your Honor, is that the court is basically saying that this is both ambiguous and not ambiguous, because the court ruled that it was ambiguous, but they imputed two specific terms. One, of course, was that Mr. Williams had an obligation to repay the money. And I would point out, Your Honors, that was a contractual obligation. The court specifically said that he had a contractual obligation. It wasn't predicated on some kind of common law obligation. The court specifically said that there was an implied contractual obligation to repay the money. So the court imputed a term of that contract that was not in the contract. Secondly, the court imputed a date of breach when the contract has no mechanism for determining the date of breach. And I think this is a very important point, Your Honors, that the court determined that the date of breach was June 30th of 2009. Beyond the fact that that's not in the actual document, in the documents, there's actually no evidence to suggest why the judge even came up with that date. The testimony of Chad Robinson, who was one of the experts, with the defendant's expert, the judge used that testimony to decide what the agreement meant, because the judge used that testimony to decide what production meant, because the dispute was, was Mr. Williams entitled to use this money for marketing and distribution as well, or just production?
Ask you about that for a second, because sure. I was concerned about something that I read in your brief. As I read the brief, it said that it was error to rule that the contract was not ambiguous, and then it was error to rely on the plaintiff's expert. But didn't the judge clearly say that that was an alternative ground?
Well, Your Honor,
and your brief does not suggest that at all.
Well, Your Honor, the judge did not. I don't think the judge can really have two rulings, Your Honor. I mean, the judge found that it was all the time. Can the judge find that it's both ambiguous and not ambiguous, Your Honor? That's my point here, is that
no, I think you're misunderstanding me, and that happens a lot. Mm-hmm. The judge said it's not ambiguous, right. But even if it is, Campbell still wins. We see that every day in civil court. Right.
What my point, Your Honor, here is he used the testimony of Mr. Robinson while saying that he wasn't going to use parole evidence. So that.
Okay, but I think we're talking in circles then. He used it. He basically says, if I'm wrong, that the contract was ambiguous and I find otherwise. But if I'm wrong, then I use the expert testimony and Campbell's client still wins. So. Right.
But the judge had made rulings that prevent that pretrial rulings in response to your question. The judge had made pretrial rulings that basically said that some of the Mr. Williams, parole evidence was not going to be counted because the contract was unambiguous. And then he used the testimony of Mr. Robinson. So if this case is remanded, which is what we believe the remedy is, that this court order that the contract is ambiguous and that parole evidence therefore is admissible, and that there would be another trial and both sides would get to introduce their parole evidence, Your Honor.
Okay, but let's read together page 45 of the transcript of his findings.
Yes, Your Honor.
Starting at line 20, he says, now giving my findings that these two contracts are fully integrated documents and are unambiguous, so far in construing the production agreement, I have not considered any extrinsic or parole evidence. But if my finding is incorrect and I were to consider parole evidence, I would still find.
Right.
These were alternative theories. He didn't find it was ambiguous and unambiguous. I think that's a deceptive argument.
Well, respectfully, Your Honor, I don't think it's deceptive in the sense that the ruling, as you say, Your Honor, the ruling very clearly said, I find that this is unambiguous. And then he says, if it wasn't, but really,
No,
Your
he says,
Honor,
if I'm wrong. In other words, if Meade, Blake, and Lemire think I'm wrong, then I would still find the same way, considering parole evidence of Chad Robinson.
Right, but if he had said, if his ruling was, I'm considering parole evidence and I'm finding in favor of the defendant, that would give the plaintiff different grounds for appeal that weren't available when he said, I find that this contract is unambiguous, Your Honor. So as a procedural issue, that by finding that the contract was unambiguous, but then saying, well, if it wasn't unambiguous, he found that it was ambiguous, Your Honor. So that's why we're appealing it based on that ground. If he's saying that he allowed parole evidence, then the issue is he didn't allow parole evidence of Mr. Williams. And so that's a different issue for appeal.
Well, but isn't that in part based on your client's conduct and discovery and the like?
Well,
and that hasn't been separately appealed.
It hasn't, Your Honor. My understanding, again, I was not trial counsel, but of course I'm familiar with the case. My understanding, Your Honor, is that while there were some discovery orders that were, not very good for my client, the reason that my client was not allowed to present certain experts was because the judge said no parole evidence, therefore it's not ambiguous, and you don't get this testimony. That is my reading of what
I
happened.
think we just read those differently, counsel.
I suppose that we do, Your Honor, and I don't know, so seeing as how I only have a few seconds left, Your Honors, thank you for your time, and I would request that you rule in favor of my client. Thank you.
Campbell.
Thank you, Your Honor. Thank you, members of the court. My name is Tom Campbell, and I was lead trial counsel for Mr. GRIECO and for the LLC, and represented them in the years prior to the trial. Basically, Mr. Williams tried this case on the theory that production and distribution and marketing expenses were all one for the purposes of the production agreement, and the LLC investment funds could be used for any of those three purposes pursuant to the production agreement. There was never any argument below by way of motion in limine, by way of opening statement, closing argument, post-trial motions, to the contrary. And the idea that the parties always argued that the contract was ambiguous is not consistent with the decision to bar defense expert Dean Shaley prior to trial. The motion in limine to bar his testimony was based on Mr. Shaley's proposed testimony that would have been basically conclusory and wouldn't have shed any particular light on the technical issues relating to film production. Skipping ahead to one of the questions that Justice Blake asked about, that Justice Lemire asked about breach of fiduciary duty. That wasn't raised below at all. It wasn't raised in the brief. There's no case law cited to it. It wasn't argued at all. No authority was presented. And I would go on to say that the idea that no evidence was adduced as to the date of the breach, significant evidence was adduced as to the date of the breach. This case went on for 5 to 10 days of trial in the business litigation session, and the judge found a fact, which he was entitled to do as the fact finder in this matter, that the film was completed on June 30th, 2009. So
Can we back up for a second on the breach of fiduciary duty claim? Is it your view that we could say that because he didn't raise it or brief it and the damages are coextensive, we don't have to reach the other claims as to whether or not the contract is ambiguous and there were missing items?
yes. When there's no, when the judgment rests on independent grounds that have not been appealed from, Mr. Williams has failed to meet his burden of demonstrating any prejudice. I would cite to Marlowe versus City of New Bedford, 369 Mass 501, 1976. In that case, there were two alternative grounds for the trial court's ruling. To succeed in the appeal, the plaintiff had to prevail on both grounds. Because the first ground was upheld, the court did not reach the second ground. Another case, VMark Software versus EMC Corporation, 37 Mass Appeals Court, 610 in 1994. In that case, the trial court properly ruled in the party's favor, but should have done so on a misrepresentation claim instead of a breach of contract claim. However, the fact that the ruling was proper with respect to misrepresentation made it unnecessary to expound on the appellant's breach of contract arguments. And I cited a case in the brief as well, Robinson versus Planning Board of Hingham. Now, when below, the defense was content to argue basically that there simply wasn't any breach at all. that this was a case of buyer's remorse, that Mr. Williams didn't breach the production agreement or his fiduciary duties. That was how they argued their case, that he could spend money on distribution and marketing, and furthermore, he contributed outside money towards the completion of the film. Down below in the trial court level, there was no argument, there was no motion to alter or amend, there was nothing in the proposed findings of fact and conclusions of law. And I would add that there's nothing cited to in the defendant's brief. So there's no objection that's been preserved for your review. Again, you can't try a case on one theory and then, when you lose on that theory, argue new issues on appeal that were never raised below.
Why do you think you're entitled to fees and costs?
This is this case doesn't raise any precedent. It doesn't cite to the record. It doesn't present any viable grounds for reversal to this court. It doesn't make any argument that the law should be changed. Basically misrepresents or ignores important findings that the court made, such as the finding that the contract was unambiguous. But then if I'm wrong on that count, I will consider parole evidence in addition to.
So you read that the way I suggested to your brother, that it's an, if I'm wrong about it being unambiguous, your client still wins on the parole evidence argument.
I agree, Your Honor. That's what I argue in my brief. I think the court was very, very clear. Judge Salinger said, these are the reasons why I'm finding this contract to be unambiguous. However, if another court should disagree with me, I would still find that the contract was unambiguous for these reasons. And he's discussed not just the trade usage that was discussed in Chad Robinson's testimony, but he discussed a number of issues as well.
And are you aware of any cases that say that the lack of a remedy in a contract makes it ambiguous?
No. And I would add that this goes to your previous question, Your Honor, concerning frivolity of the appeal, because none are cited in the appellant's brief. And I don't know of any. I'm not aware of any concept in contract law that says that a contract is ambiguous if the remedy for breach is not specifically spelled out within that document. It's pretty common to award expectation damages to a non-breaching party.
Your brother relies on the Fay case pretty substantially in his brief 1979 case against the Massport. What are you? Can you tell me why you say Fay is inapplicable here?
Yes. In the Fay case, the court was looking at a situation where the contract between the Massport and the engineering company didn't spell out what would happen in the event that a project was changed and the underlying construction project was for less money than had been contemplated within the agreement itself. So that to the Fay court was an essential issue that was missing, and therefore they had to look at surrounding facts to understand the contract and the intent of the party and the interpretation of the terms of the contract. But in this case, if the court decides that the production agreement and the operating agreement were ambiguous as to the meaning of production costs, Judge Salinger turned to a full trial on the merits, not just the summary judgment motion and summary judgment affidavits. There were 5 years of discovery in this case. This motions practice in this case was hard fought. Mr. Williams was deposed for a couple of days. Mr. GRIECO was deposed, and on and on. Thousands and thousands of pages of documents were produced, and there was expert testimony. both by way of affidavit in pretrial motions practice and by way of trial testimony. So, you know, parole evidence is used to elucidate the terms of a contract that may be unclear. But I thought Judge Salinger gave a very reasoned and thoughtful explanation of the rationale that he utilized in finding that the contract was not ambiguous. He cited at length the differing usage of the term distribution versus and as opposed to production that was used in Exhibit A to the operating agreement, which distinguished between those two terms. Different sections of the production agreement, Section 1 of the production agreement, Section 2 of the production agreement, and Section 5, which separately and distinctively talks about distribution of the project as opposed to the production of the project. So he also explicitly heard testimony from witnesses for Mr. Williams who said that distribution and marketing are commonly also considered to be production in the film industry. And he said, I find those witnesses to be not credible, and I disregard their testimony on those issues. So I think the record is clear on the basis of the oral findings that were delivered from the bench by Judge Salinger that he thoughtfully considered all of the evidence in the case, and he discussed all of the evidence that was adduced during the case in rendering his decision. If the argument is that this case is, oh, by the way, I would say there are a couple of, I cited to Marlowe versus City of New Bedford and VMark Software versus EMC Corp. For the idea that when a judgment rests on independent grounds that are not being appealed on, the witness, Mr. Williams has failed to meet his burden of demonstrating any prejudice. There's another case called Millennium Equity Holdings versus Malowitz, 456 Massachusetts 627 from 2010. And Riley versus Davison Construction, a 1980 case, 381 Massachusetts 432. I apologize for not having cited those in my brief. With respect to the fiduciary breach piece, this was a closely held entity. Mr. Williams clearly owed a duty to that closely held LLC. There's only two members of it, Williams and GRIECO, and he breached his duty to the LLC by spending more than half of the LLC's film investment funds on personal expenses. So the damages for that breach are coextensive with the damages for breach of contract, and he must repay that same amount. And where the brief doesn't mention the breach of fiduciary duty, the reply does not mention breach of fiduciary duty, and there is no post-trial motion raising that issue either. I think that the court can dispose of the appeal on those grounds. Does the court have any other questions?
Seeing
Thank you,
none,
Robert.
thank you.
Thank
Thank
you.
you both. Thank you. Welcome to the appeals court. Excuse me. I'm Justice Meade. With me today are Justices Blake and Lemire. If we run into any technical difficulties, don't worry. We'll reestablish contact with you, and no one will be denied any of the allotted time, which is 15 minutes aside. And if there'll be no rebuttal. So with that, I'll call our next case. It's 2020 P 257 Rowley versus the City of New Bedford. Ms. Rowley.
Good morning, members of the panel, and may it please the court. My name is Joyce Rowley. I'm the appellant petitioner pro se. And in this memo,
can I stop you there?
Sure.
Yeah. Can you explain to me how you're authorized to do this, and it's not the unauthorized practice of law? Because you didn't seek a writ for yourself.
correct, but under the writ, someone who is knowledgeable of the condition of detainment is able to file a petition, and that person may be pro se.
But you can't. But you're not appearing for yourself. You're appearing on behalf of the elephants. Your liberty has not been restrained.
No, but
I just want to point out that under Chapter 221, Section 41, the unauthorized practice of law carries with it criminal penalties, and the remedy for petitions brought by people unauthorized to practice law, the remedy is dismissal. I know this wasn't brought up in court, but because it was summarily dismissed, of course. But I also, for what it's worth, I don't understand how you have standing either.
my standing is based on my knowledge of Ruth and Emily's detainment. This was not brought up not only by the court, but it was not brought up by the defendant city as well.
I understand that, but Ms. Rowley, standing is something we call subject matter jurisdiction that we can raise on our own in the first instance, sua sponte.
I do have standing because I have observed the elephants for close to 10 years. I've observed their detainment, and in fact, I presented this within the petition itself. This is where they live. They live behind bars.
No, I understand.
I have seen them.
No one doubts the sincerity of your beliefs and feelings. That's not what I'm talking. But your legal interest has to be something separate than that's available to the general public, which I don't understand.
Justice Meade, I point out that her petition was filed under Chapter 248, Section 36. And it says whoever has reason to believe that another person is deprived of his liberty or held in custody may file a petition.
Well, I don't want to detain the argument any longer. You go ahead and tell us, Mrs. Rowley, what you'd like.
Thank you very much. I do appreciate the opportunity to argue this case. As I understand it, the law only has two statuses. Either there are either things or persons. And in this case, Ruth and Emily clearly are not things. They are legal persons. They're capable of thinking. They have spatial temporal memories. They have self-cognition. Their brain structure is a lot like ours. They have the capacity to understand the difference between freedom and captivity. And in my petition, I demonstrated exactly how they have shown that they prefer freedom. They've rammed the gate. Emily has rammed the gate. There's videos of that. There's clearly photographs of Ruth trying to unlock the lock on the chain on the gate, which is the only access out of the exhibit. Ruth escaped during a blizzard in the barn, a huge barn, for no reason other than she wanted freedom. And these are not just innate responses. These several examples are how they clearly have the ability to reason. Furthermore, they have the capacity for emotions, pain, to communicate that same pain, but also the city recognizes this. The petition begins with a quote from the elephant management protocol that the city has, which states that if one of the elephants passes, the surviving elephant will be given time with the remains of the deceased elephant. It's common knowledge that elephants now agree that we recognize this. This is 2020, not 1920. And clearly, if there are only two options, things or legal persons, Ruth and Emily are not things. I believe I provided enough of a foundation for this court to find that. I have shown the various international courts, which are now coming to that same conclusion, particularly the Islamabad High Court, which recently decided the case of Kavan.
Ms. Rowley, if I could just if I could interrupt you for a minute, you know, oftentimes in divorce cases, people are very attached to their animals. They consider them like their children. And the power of the probate and family court to address a dog or a cat is unfortunately as a thing. There are not custody rights. Parties can agree to anything, but I understand your argument, but when we look at how animals are treated across all aspects of the law, unfortunately, I think for your argument, they're not given the status that you're asking for.
Well, and actually, and that's a good case in point, is that they now do have the ability, courts do have the ability to give an order of protection for a domestic companion animal during a domestic violence situation. So the court has been progressing in that direction. In Commonwealth versus, and I'm not trying to practice law, mind you, but in a case that I found, Commonwealth versus Heather Duncan, police executed a warrantless search on behalf of 3 dogs, 2 of which were already dead. The third was close to death, and the court upheld it on the basis of emergency aid, not probable cause. So clearly, emergency aid had only previously been used for humans. So clearly the court's moving in that direction. And I think that's the pivotal point. Not necessarily that there has been in Massachusetts a case where any animal has been given, designated as a legal person. But that there's foundation.
The writ that you've filed under is a creature of statute. The legislature created it. And it refers to persons. So if it should be extended to non-humans, that should be the job of the legislature.
In common law, I believe the court has the ability to then look at the definition of person and expand it, as it did in the matter of Commonwealth versus Cass to a viable fetus who was killed in a car accident.
But that's still a viable fetus is still a human being.
And the court did cite that, but it also said that the way that they reached that conclusion of extending now to another entity was through the ability to use these other cases to show that public policy was going in that direction. And certainly with the case that I just cited of Commonwealth versus Duncan, the court also said that there's this web of laws that now protect animals. However, in this case, those laws are not adequate. This morning, I had to file an injunction at the lower court because one of the 2 elephants, Ruth, in October, not only is she lame without any treatment, she is now apparently blinded in one eye. And that occurred sometime around October 7th. Again, to my misunderstanding, I didn't properly file the motion, but I corrected the errors and filed it this morning. It's an injunction to be considered guardian ad litem, to be able to find out what's going on with them, but also to bring in an independent veterinarian. Humanitarian laws are just not serving these elephants, and they clearly deserve the right to not only bodily liberty, but to freedom from abuse. This is not, and I'm off script, unfortunately. I had planned a whole different argument for this morning to cover not only the issue of whether or not they're persons, but then whether or not the Endangered Species Act lawsuit decision designates them as lawfully held as captive. So I would like the ability to complete that argument as well in the event that the court would like to hear it.
You still have 5 minutes.
Thank you so much. So the first portion of the appeal was the Superior Court denied based on personhood. And the second is that the Superior Court found that the Endangered Species Act lawsuit had supposedly had stated that Ruth and Emily are lawfully held captive. And that is not the case. The Endangered Species Act lawsuit was not about either personhood or their captivity. In fact, the decision states that Judge Young clearly said that whether or not they were captive has no legal bearing on that case. And I, in my brief,
find that they were well taken care of and in good health for their age.
No, actually, that's not only not in the record in this case, but in any event, Ruth is lame and has not had medical treatment for that other than ibuprofen. She's not had x-rays. And whether or not I'm an expert really doesn't matter, because if I had a dog that was lame, I wouldn't have to be a veterinarian to know that. And if the veterinarian did not do the x-rays, if I brought my lame dog into a veterinarian, and the dog was obviously in pain, the vet did not do x-rays, I'd go to another veterinarian, and that's exactly what I'm seeking. Neither elephant is in great health. As I noted in the petition, both have infections on their feet, on their skin, on their face, open weeping sores. This is not necessarily, if there were a dog in that state, they would be removed. It would be a felony for anyone who kept an animal like that. They're put inside of a barn with the dirt floor for 16 hours a day. And those conditions, what lead to these, particularly these abscesses and weeping sores. Ruth certainly is in worse shape than Emily, but Emily also has had an infected tusk. Very painful and also very dangerous. These are not things that should be occurring or would be occurring if they had, if they were treated as legal persons and not things. As far as the relief I'm seeking is to be appointed guardian ad litem, understanding that if the court were to not put me in jail for trying to practice law, apparently, which is not my intention.
I'll be clear, that's not our intention.
Okay, very good. I do apologize for not looking at that thoroughly prior to today. I would have a better answer for you had I realized that was going to be a problem. But for relief, the reason I'm seeking to be appointed guardian ad litem, both in the injunction and in this matter, is because were I to be successful and they were to be designated legal persons, they couldn't be released just to the outdoors. There's no facility in Massachusetts appropriate for them. There is in Tennessee and in Georgia, the refuge in Georgia has offered to transport them. That particular person has transported over, the founder of the refuge in Georgia has transported over 20 elephants, is very familiar with the process, but also whether or not Georgia would recognize their legal personhood. By my being designated a guardian ad litem, I could ensure their freedom continuously. And I do thank you for providing the opportunity for oral argument in this matter.
You have time remaining, and I used up some of your time at the beginning. So if there's something else you'd like to tell us, please go ahead.
I can only reemphasize that Ruth and Emily are not things, and that expertise in that is not necessarily needed. This is something that has been thoroughly reviewed by other courts, not just the Islamabad court, but certainly the courts in New York. There has been lengthy discussion of how to treat such sentient beings. My experience with them
New York cases,
be undervalued.
The New York cases, did the judges, did any New York court find that an elephant or a chimpanzee was a person?
No, they did issue writs, but after discussion did not, because of precedents. Although I believe one of the cases, the case for Happy the Elephant at Roxy, I believe is still being argued on appeal. But I understand that it would seem a leap of faith, except that it's difficult for me. it's just an answer to that. It's difficult for me to see them as things, as inanimate objects that have no value or rights of their own. Thank you so much.
I just have one brief question, Ms. Rowley. This is Justice Lemire. Your petition says you filed it procedurally under Chapter 248, Section 36. Is that correct?
That's correct.
And when I read that statute, it says it would be filed in the probate court.
That's correct. And when I checked with the Massachusetts court's application online, it said it could be filed either in probate court or in Superior Court, which is filed in Superior Court.
All right, thank you.
Thank you very much. Mr. Markey?
Thank you very much, Justice. May it please the court, my name is John Markey Jr. From the firm of Markey & Walsh in New Bedford, and I am representing the city of New Bedford in the case. I initially would like to thank Ms. Rowley for the fact that it is clear, as the court has already recognized, how genuine her feelings are in this issue, how much time of her personal life she has invested in what she believes to be the case. But with all respect, I think she's misguided on the law in this case. And I think, as Judge Young found, she was somewhat misguided on the facts in the case that was fully developed up at the federal court. And the primary part of my argument would fall upon Justice Meade's point that if there was a desire to give animals certain protections such as this, it would be the realm of the legislature to have done so. And that has not happened. But if we were to look at a broader swath of the law, it is clear that the law sees not just persons or things, the law sees animals as a distinct category based upon the fact that there are statutes that grant protection to animals if they're, or in one of the cases cited by Ms. Rowley, malicious killing of a cat can be a crime, but it's separate from an assault and battery on a person. So the evidence from the legislature, even those things cited in Ms. Rowley's case, say there's really a third category. And animals, I personally am not a cat and dog lover, but I understand and I appreciate that Justice Blake's reference to the importance in many probate matters that animals can be a very important part of people's lives, but they are animals. And I think that, as Justice Meade mentioned in responding to Ms. Rowley, the fact that a fetus is a human being in process distinguishes it substantially from a cat, a dog, a lemur, or an elephant. And so I think that in regard to whether this court should look to overturn the trial judge on the personhood determination, there are no cases in Massachusetts that would suggest it. There are no cases in the United States that would justify it. I was unaware of the Islamabad case that Ms. Rowley mentioned, but it's certainly not within the realm of the Massachusetts Appeals Court to rely upon something in Islamabad when nobody in the United States has done so, and when the Massachusetts legislature has most clearly identified that animals are a distinct category and that there are some laws that would grant protection to them. Certainly, because elephants are endangered species and are rare, the Massachusetts legislature has not spent a lot of time writing laws and guidelines on elephant care and maintenance, but the court can be instructed by Judge Young's decision and by the Endangered Species Act, where people much more expert than myself and in candor, much more expert than Ms. Rowley, are looking at the standard of care for elephant husbandry at a national and international level and taking best practices and putting them into standards. And as Judge Young found in a thoughtful 32-page decision, which although the decision itself was not in the record, the fact is the decision with a specific citation was in the decision. It's my view that the trial judge had absolute right to take judicial notice of a case brought by the same parties in alleging the same basic facts and rely upon those findings of fact and findings of law that basically the city of New Bedford not only was meeting a minimal standard, but was exceeding that standard and continuing to improve in its care of these two elephants. And, yes, Judge, sorry.
I don't disagree about judicial notice, but it's my understanding that this case is on appeal in the First Circuit. Is that correct?
I apologize for not updating the court, but the First Circuit ruled to uphold the decision of Judge Young. And then Ms. Rowley filed an en banc request, and that request was denied. So,
So it is fine.
It is final. I'm not sure of the timing of whether Ms. Rowley intends to file with the United States Supreme Court. I don't know. Candidly, I haven't looked at what the timing would be for that. But this fall,
90 days from a final judgment.
Okay,
From
well,
a final decision.
thank you, Your Honor. So perhaps she may be doing that. So if that makes it not final, then the court, I would recognize is not final. But the reality is Judge Young was very thorough after a very lengthy trial with multiple experts to write the decision. The First Circuit upheld the decision. The First Circuit en banc denied further review, and that's where procedurally it sits. In regard to any of the other issues, I don't want to just reiterate what the court has already seen in the papers, which I think we laid out fairly well, is that there are, in essence, just to summarize, unless the court has further questions, there are three categories. There are people, there are animals, and there are things. People have the rights under the writ of habeas corpus. People have the right to appear pro se. People have lots of rights, regardless of their stage of life. Animals are an important part of many people's lives, but they're different and distinct, and an elephant is an animal and therefore not entitled to the claims. Furthermore, even if there were a desire to go beyond that and take a look at whether proper procedure had been given to the animal, first, the Judge Young provided ample time for presentation by Ms. Rowley and ample due process for their rights, knowing full well the manner in which the elephants were being cared for, and made a determination that the care was appropriate and was above the standards that would be expected. With that, Your Honor, unless there are further questions, I would waive the remainder of my time.
Seeing none, I thank you both, and we'll take this under advisement.
Thank you, Your Honors.
We are live and on the record.
Welcome to the Appeals Court. I am Justice Meade. With me today are Justices Blake and Lemire will be your panel. If we run into any technical difficulties, we'll do our best to reestablish a connection that should it be lost, and no one will lose any time on their allotted argument, which is 15 minutes. We don't entertain rebuttal. With that, I'll call our last case, 2020 P153 Mancuso versus 263 through 269 Pleasant Street LLC. Mr. Primison.
Good morning, Your Honor. May it please the court. My name is Webb Primison, and I represent Lisa and Philip Mancuso, who are the appellants in this matter. It is our position that the primary error made by the trial judge in this case was the finding that Chapter 48, Section 16 was not violated. And my brother, in his brief, has argued, obviously, that his position is that the statute was not violated for essentially two reasons. He says, as I understand it, first, that the remand, the manner in which this matter got back to the Zoning Board of Appeals, and the description of that procedure as being a hearing on revised applications means that the statute does not apply. Secondly, my brother contends that when a ZBA issues a written decision on a matter, and that matter is appealed, the decision which formerly was final suddenly becomes not final because it's subject to judicial review. I disagree with both of those positions. And I'll attempt to indicate to you why. The statute, as I know you know, is not designed to confer any benefit on a landowner applicant or to place any barriers before a landowner applicant. It is for the purpose of alleviating the requirement that neighbors, abutters, others who oppose the particular proposal not have to repeatedly go back to the zoning board and express their opposition. To me, when the land court in this case remanded the matter to the ZBA, whether you call it a revised application or not, it is clearly, in terms of substance rather than form, a second application. The representation was made to the court by the parties that they had revised plans and that these plans were believed to potentially satisfy the problems that the zoning board had found in its initial decision when they denied the special permit by a vote of 5-0. Well, since the reason presented to the court was that they have, in essence, a new plan or a different plan, that's the point at which we say Chapter 40A-16 comes into effect. And that is that the planning board or someone else needs to look at the representation made by the parties and see whether or not the zoning board ought to rehear the case or hear the case on revised applications according to the statute. If my brother's argument is correct, then on remand, if this zoning board had, instead of issuing a decision granting the special permit, if they had again denied the special permit, then the developer landowner would have the right to appeal and potentially amend plans again with the intention of complying with whatever problems the zoning board found in support of their denial, ask the court for a remand, and go back to the zoning board of appeals, and could do this multiple times. And in our view, that is precisely the substance of the purpose of the statute, not requiring people to keep going back within a 2-year period to the zoning board to express their opposition to the application for the special permit. That's really my argument, Your Honor, in a nutshell, and what I wanted to emphasize in the argument today.
Well, Mr. Person, this is Justice Lemire. You agree the court has the authority to remand?
I do.
And the remand order of the court was that it go back for a full hearing on the case that they described, remanded to the board for a full, fair, lawfully noticed public hearing.
That is correct.
So they're complying with an order of the court.
Well, I don't see how, with all due respect, Your Honor, that a land court judge can overrule a state statute. In other words, if this is a new application, because it's clear that the initial application was unfavorably acted upon, in the words of Chapter 48, Section 16, the May 2016 decision is unfavorable. Now we have a second bite at the apple, if you will. I agree, ordered by a judge, but there's nothing that in the judge's order or in any of the process that was gone through that would have prevented the developer, landowner in this case, from going to the planning board to seek consent. And it's our position that that's what should have happened. And that the judge, I'm guessing, but I'm not guessing that the judge ignored the statute. I'm guessing he expected the parties to comply with 4816, go to the planning board, and then if consent had been granted, go to the zoning board.
I have nothing further.
Mr. Feldman.
Thank you. May it please the court, my name is Paul Feldman. I represent the appellee 263, 269 Pleasant Street. With regard to the applicability of 48 Section 16, put simply, zoning remand orders of a court, be it the land court or the superior court, are not subject to 48 Section 16. We have found no case in the Commonwealth that has held that a remand order in zoning cases that may result in a reversal of an initial unfavorable decision is subject to 48 Section 16. To do what Mr. Privison advances on behalf of his client is to alter decades of well-established practice by the trial courts in handling expeditiously zoning matters, and would be contrary to the Zoning Act and frustrate its purpose. So there are two portions of the Zoning Act that we maintain are in interplay here, Section 16 and Section 17. And Section 16 places a effectively a two-year time bar on an applicant that desires to pursue a new petition for the same relief that was previously and finally denied. So I will get back to the term finally.
Let me ask you this, Mr. Feldman. If the initial land court Section 17 appeal had been finalized and the land court ruled theoretically that the board's action was appropriate and therefore denying the plan, you'd agree that if they wanted to submit revised plans at that point, they'd have to comply with Section 16 and wait the 2 years.
Well, that's right. They would have. That's correct. Had there been a trial and the board's decision to deny the plans were upheld, the decision wasn't disturbed. That unless that decision was further appealed to this court, it would become final. And once that decision was final under those circumstances, the only recourse for my client would be to submit a new application, presumably for a similar or different project or a completely different development of his land. So I would agree with that.
So essentially the parties agreed to avoid that by not going to trial and asking the court for a remand.
Well, in this particular case, very close to trial, correct. By an assented to motion, both parties went to the judge to say that they believed that it was in the interest of resolving this matter for the matter to be remanded to the zoning board for further consideration. And the specifics of what the judge ordered is set forth in the remand order in the record. But importantly, I would note two things. Number one, Judge Vey had to independently decide that that was an appropriate order of the court or an order that the judge thought it should be entered and under what terms and circumstances to enter the order. The fact that parties presented assented to motion doesn't make it necessarily an order until the judge independently determines it should issue. And the second thing we would say is that and there is some speculation in the appellant's brief as to what was motivating the remand, but the fact of the matter is there's lots of reasons why, including a desire by the zoning board, after seeing how the case was going to be presented, to want to have another opportunity to further consider what they had done, because perhaps the zoning board was concerned about the outcome. So that procedurally is where we found ourselves. Both parties asked the court to consider remanding the matter for further consideration. The court determined that to be an appropriate order, an appropriate and equitable way to resolve the matter for the moment, and sent it back to the board.
What would have happened? What would have happened if the parties just, and again, this is off the record in the sense of this isn't what occurred, but what if the parties had instead said to the land court, Judge, we're going to go back. We've agreed to go back, so we're just going to dismiss this.
I think if the parties would have done that, or frankly, if the parties asked the court to just continue the trial because they want to go off and do something alternatively, the case would be before you in a different posture. That
I understand, but would Section 16 apply if it was dismissed and gone back under the same terms by an agreement?
I think there would be, well, you wouldn't have to have agreement of the parties to dismiss the case, and well, I guess you would at this point, but the point is, yeah, I think under those circumstances, Mr. Primison's argument would be completely different, and his reliance on the Remy case, for example, the Nantucket case, would be appropriate, more appropriate than it is in this context. If you recall, in the Remy decision, an appeal was taken of an original denial, and then the applicant chose to submit a revised plan to the board on his own. And as the court said in that case, not a bad position for that applicant to choose to do, didn't want to keep all his eggs in one basket on the appeal. But if that's what the applicant chose to do, then, as the court pointed out, the applicant needed to comply with 40A Section 16. So we think that it is significant, important, almost determinative that the reconsideration by the zoning board in this context was as a result of a court order by Judge Vey. And I would point out two things that I would disagree with Mr. Primison about what he just said. The first is that I don't know how, Mr. Primison said he was guessing that the judge expected the parties to comply with 48 and go to the planning board. I don't know why anyone would draw that inference if you read the remand order that is in the record. The remand order says, it was issued on October 10th, put notification in the Marblehead Reporter 2 days later on October 12th for a zoning board hearing that must take place on November 6th. And to properly notice that zoning board hearing, you need to get your 2 weeks of successive notices in the paper, so you have to start that by October 12th. The only inference you really should draw from that is Judge Vey had no expectation that there should be any activity in front of the planning board. But Judge Vey specified in his remand order what the parties should do. And I want to point out, as we noted in our brief, that this court has already held that a judge in issuing a remand order can vary from some of the statutory provisions set forth in the Zoning Act, notably Section 15. This court has already held that in a remand order, the judge can specify the timetable on which the board can act, and therefore things like constructive approvals and other things that the Zoning Act and the statute provides as a matter of law are not operative because of the broad power the legislature gave a court in 48 Section 17. And as you will note from our brief, that is really what's going on here. This court is being asked to reconcile and give meaning to all the various provisions of the Zoning Act and harmonize them. And it's easily done in this case. 4817 clearly gives the authority to Judge Vey that Judge Vey chose to exercise. This court has already said in exercising that authority, not every provision of the Zoning Act need be complied with. You said that in connection with Section 15, and certainly we would say it's even easier to come to that conclusion with regard to the repetitive petition provisions because, first of all, a remand is a continuation of the original proceeding. It is not a new filing. It is not a new petition. It is a continuation of an existing proceeding. And I would note, even though it was in a different context, in the Petrillo decision that we note in our brief, this court in footnote number 9 was very clear to say that a zoning decision which appears to be final at one point in time may not be final throughout its time because it can be further considered. So when Mr. Primison says he doesn't understand how you can have a final decision that becomes unfinal, this court fully appreciated it and understands it. It's so noted and explicitly held in Petrillo in footnote number 9 that it was explicitly finding that zoning decisions do not have finality, and in that case it was for purposes of res judicata, because that finality is temporal and can change. What we would say, Your Honor, Your Honors, is that to alter 50 years, 60 years of the practice of the trial courts and the bar in such a dramatic way and limit the power and the authority conferred to the trial court judges to enter orders as justice and equity would require, to expeditiously have zoning cases move along by now saying, if there is an unfavorable decision, the only way that decision can be reconsidered by the board is either wait 2 years, or you now have to go to another board like the planning board, who has to now make an independent determination. All we're doing is creating more litigation and more uncertainty, and we can find ourselves in circumstances that a board like the planning board, that it was not a party to the case that was before the trial judge that was remanding decision, is now making decisions that can be inconsistent with what the zoning board ultimately decides, and we just have further litigation. We have unnecessarily and inappropriately complicated what is a well-established and known practice by members of the bar in the Commonwealth and the justices throughout the trial court system. We point to a number of other cases and decisions in our brief where this kind of remand has occurred without objection. I just want to mention to the court the case of Titcomb that we cite, because we painstakingly review how the posture of Titcomb and the appeals court decision, this court's decision in Titcomb, was exactly the circumstances that we find ourselves in, and the appeals court felt no need to consider the Section 16 implications because I think it was obvious that Section 16 was not applicable in the circumstances, and this court should not make it applicable now. I know that Mr. Primison spent no time in oral argument on the second issue of appeal. I'm not going to, I have 59 seconds left. I'm not going to spend any time on it, just to note that the Judge Barrett's decision on preclusion board testimony was absolutely correct, and that issue has been waived, and there's no basis to reverse his decision on that score. And we would ask that the court also affirm Judge Barrett's determination that 48 Section 16 is not applicable in the circumstances of a remand order by a trial court judge directing a zoning board to further consider the original application under changed circumstances. But thank you very much.
Thank you. Thank you both. We'll take this under advisement.